Good evening and welcome to Desi's Desires Live and my ongoing series of pornography, fantasy versus reality. There's so many issues related to the porn industry that are affecting the lives of Americans in our country every day, and I'm here to talk about them. Tonight I'll be discussing a Supreme Court's decision in January 2009 refusing to uphold a law passed by Congress in 1998. That law would have protected our children from exposure to hardcore pornography on the internet. This is a very prevalent problem that is damaging our children at an alarming rate. I pulled information on the actual law from Wikipedia, so I'll start by reading what this law entails and what has happened in the court system since it was passed in 1998. The Child Online Protection Act, shortened to be called COPA, was a law in the United States passed in 1998 with the declared purpose of restricting access by minors to any material defined as harmful to such minors on the internet. The United States federal courts have ruled that the law violates constitutional protection of free speech and therefore have blocked it from taking effect. As of 2009, the law remains unconstitutional and unenforced. The law was part of a series of efforts by U.S. lawmakers legislating over internet pornography. Parts of the earlier and much broader Communications Decency Act had been struck down as unconstitutional by the Supreme Court. COPA was a direct response to that decision, narrowing the range of material covered. COPA only limits commercial speech and only affects providers based within the United States. COPA required all commercial distributors of material harmful to minors to restrict their sites from access by minors. Material harmful to minors was defined as material that by contemporary community standards was judged to appeal to the prurient interest and that showed sexual acts or nudity, including female breasts. This is a much broader standard than obscenity. The federal government was enjoined from enforcing COPA by a court order in 1998. In 1999, the U.S. Courts of Appeals for the Third Circuit upheld the injunction and struck down the law, ruling that it was too broad in using community standards as part of the definition of harmful materials. In May 2002, the Supreme Court reviewed this ruling, found the given reason insufficient, and returned the case to the Circuit Court. The law remained blocked. On March 6, 2003, the Third Circuit Court again struck down the law as unconstitutional, this time finding that it would hinder protecting speech amongst adults. The government again sought review in the Supreme Court. On June 29, 2004, in Ashcroft v. American Civil Liberties Union, the ACLU, the Supreme Court upheld the injunction on enforcement, ruling that the law was likely to be unconstitutional. Now, they keep saying it's likely to be unconstitutional, but they won't talk about it, they won't get it into court, and let's fight this out and decide. Notably, the court mentioned that filtering superior to COPA is confirmed by the explicit findings of the Commission on Child Online Protection, which Congress created to evaluate the relative merits of different means of restricting minors' abilities to gain access to harmful materials on the internet. So in other words, they're saying that they found that the filtering systems were better than the law. The court also wrote that it was 5 years since the district court had considered the effectiveness of filtering software and that 2 less restrictive laws had been passed since COPA, one prohibiting misleading domain names and another creating a child-safe kids domain, and that, given the rapid pace of internet development, those might be sufficient to restrict access by minors to specific material. The court referred the case back to the district court for trial, which began on October 25, 2006. In preparation for that trial, the Department of Justice issued subpoenas to various search engines to obtain web addresses and records of searches as one part of a study undertaken by a witness in support of the law. The search engines turned over the requested information except for Google, which challenged the subpoenas. I'm sure you all heard about that case. The court limited the subpoena to a sample of URLs in Google's database, but declined to enforce a request for searches conducted by users. Google then complied. On March 22, 2007, U.S. District Judge Lowell A. Reed Jr. once again struck down the Child Online Protection Act, finding the law facially in violation of the First and Fifth Amendments of the United States Constitution. In addition to the plaintiffs, the ACLU et al., several witnesses testified in defense of First Amendment rights on the Internet, including the director of the Erotic Authors Association, Marilyn J. Lewis. Reed issued an order permanently enjoining the government from enforcing COPA, commenting that perhaps we do the minors of this country harm if First Amendment protections, which they will with age inherit fully, are chipped away in the name of their protection. And I say, let's see, we'd rather protect a little free speech when they become adults compared to the fact of not damaging these minors' minds with all this sexual garbage that's out there, so that who cares, they're not going to be productive adults because they're addicted to porn, they're turning into sexual deviants, and they're having a lot of major sexual problems. I mean, there's a lot of proof out there that supports this. The government again appealed, and the case was heard before the Third Circuit. On July 22, 2008, the Third U.S. Circuit Court of Appeals upheld the 2000 decision, which means it still didn't go anywhere. On January 21, 2009, the United States Supreme Court refused to hear appeals of a lower court decision, effectively killing the bill. This happened last year. Very quietly, from the articles that I've read, it wasn't published very well. Nobody talked about it. It just quietly went away. Now let's address the three main arguments that these courts used to decide against protecting our children from internet porn, and then the Supreme Court deciding that they didn't want to deal with it, so they refused to even hear it, much less make a decision. Creating a kids domain, which would be a more effective way of addressing this issue. That was number one. Creating a child-safe kids domain, it's a great idea, but who's going to do this, and why hasn't it already been done if it's a feasible option? There's also been talk of using a XXX domain that would house all pornography and limit access to it by demanding a reliable verification of age to access it. Again, another good option, but no one's doing anything to create these domains and mandate the use of them. Our government owes a responsibility to our children and should be assigning funds to this important project instead of useless things that they do that really don't help any of us, if they don't want to enforce laws that were put on the books to protect our children. Pornography producers such as Steve Hirsch of Vivid Entertainment, the self-proclaimed king of porn, who created the current porn system that's corrupting our country, complains often in mainstream media sources of how all the free porn on the internet is hurting their industry profits. If the porn industry really wanted to fix this problem, they could create the XXX domain to put their products on and then start reporting all other websites who have copyrighted material on them and get them shut down. This would decrease children's access to porn and also get back their copyrighted material to the places it belongs. One can deduce from the fact that they complain but do nothing is because all that free porn on the internet addicts the consumer and ultimately brings them to real porn production companies' websites to see more of their products. Another issue of this decision is that parents have access to filtering systems to keep their children out of harm's way when it comes to porn. First of all, the kids are so much more technically savvy than the parents in America. They know how to bust these filtering systems by the time a parent learns about them. Statistics and scientific evidence proves that kids are watching internet porn at an alarming rate and with devastating results. The average age for viewing porn on the internet for the first time is 11 years old. This is statistics. Statistics and scientific proof don't lie. The largest group of viewers of all that free internet porn is between the ages of 11 and 17. So obviously the filtering systems aren't working. They're not keeping the kids from seeing some really hardcore sexual material that they simply cannot understand and shouldn't be